Emily, can you make sure they can hear me online?
Yes, we can hear you.
Oh, perfect. Thank you. So welcome to HYLA's discussion about the Pregnant Workers Fairness Act. We're excited to have everybody here. My name is Amber Morrison. I am co-chair of the HYLA CLE committee, along with my other co-chair over there, Harriet Wessel. And then along with Caroline Capelli and Emily Rollis, they're the Women Attorneys Committee, correct? Is that the new name? So we put this event on together. So thank you both to the three of you as well for helping us get this event started. And also to Baker Botts for sponsoring our venue and food. We also would like to thank them. So we have a really great program for you today. But before I introduce our esteemed panelists, a couple of housekeeping matters. The CLE, you will self-report. I will also tell you this again at the end of the presentation, but if you do have pen and paper or you're ready to write this down, the CLE number is 174246418, and that will be posted on Teams, and we will say it again at the end of the presentation. This will be on YouTube for you to rewatch later, but there is no CLE credit for watching it later on YouTube. You have to be present and watching it live to get CLE credit. Okay, without further ado, it is my pleasure to introduce our panelists. I'm going to start here to my immediate left with Jackie Staple. Jackie is a labor and employment partner at Jackson Walker. She is board certified in labor and employment law in Texas and is also licensed in Ohio. She focuses on compliance, multi-state issues, policy review, and drafting and reviewing various types of employment agreements. When litigation becomes reality, she defends companies in agency charges and lawsuits, particularly wage and hour, discrimination, harassment, and whistleblower claims. She is a mother of a 2-year-old and a 12-week-old. She is well suited to speak today about the PWFA, and I have to give her a shout out because she is here on her maternity leave to be here with us and speak with us. So thank you so much for being here. To her left is Samantha-Anne Nadolny. She serves as the Vice President and Associate General Counsel for Select Water Solutions, formerly known as Select Energy Services, a publicly traded oil field infrastructure and chemistry solutions company here in Houston, Texas. Prior to Select Water, she served as General Counsel and Chief Compliance Officer of Citylum,
Close though.
U.S., an EDF group company based out of Paris, France. Samantha-Anne has over 10 years of experience as a general counsel and in-house legal specialist. Outside of work, Samantha-Anne serves as chair of the board of trustees of our sister organization, the Houston Young Lawyers Foundation. She is a former HYLA board member and committee chair of Adopt an Angel. And so if you are interested in HYLA, please come talk to Samantha-Anne after the program. To her left is Ian Scharfman. Ian is the principal attorney at the Scharfman Law Firm. Mr. Scharfman is board certified in labor and employment law as well. He represents employees and practices employment law in federal and state courts at both the trial and appellate levels, along with handling such matters before various government agencies. He has received peer and client accolades, such as being rated AV preeminent, a best lawyer in America, and as a super lawyer, among others. He also served on the Texas Board of Legal Specialization Labor and Employment Law Exam Commission, and is a past chair of the Houston Bar Association Labor and Employment Law Section. He is also active in nonprofit work, serving on several boards, including the ADL Southwest Region and Fort Bend Education Foundation, and has chaired boards and committees in various other nonprofit organizations. To his left is Jackie Staple, is Ashley Lewis. This is what happens when I'm reading things off of paper. Ashley serves as counsel for Centerpoint Energy and the labor and employment and ethics and compliance practice areas. Ashley is a proud graduate of Texas Southern's Thurgood Marshall School of Law and loves to give back to future and upcoming law students as much as possible. In fact, Ashley spends her free time teaching paralegal studies as an adjunct professor at Lone Star College, North Harris. She loves her career, but she loves her 2 adorable nephews even more. With that, that is our esteemed panelists. We are so happy that the 4 of them could be here today to speak with you on this topic, and I will pass it on to our panelists.
All right. Hi, everyone. Again, my name is Jackie Staple. And I'm going to give a brief overview of today's presentation so you all know what to expect. And we are a panel, so we all may jump in on each other's sections, but we have it divided up to give you some background first. Then we'll talk about the PWFA as an overview. Then we'll get into more of a deep dive of the PWFA's language and the recently released regulations from the EEOC. Then we'll talk about the PWFA and implementation. And then finally, we'll give you some examples. And then at the end, some practical, we hope, takeaways for the PWFA. So this background section, I think, is important, and we won't spend a ton of time on it, but the PWFA was really enacted to fill some gaps that were in the law, at least at the federal level. A few states, a very small handful, had similar laws to the PWFA prior to the enactment of this federal law, but not many. And so the gaps were between two different laws, the Pregnancy Discrimination Act and the Americans with Disabilities Act. So because not everyone has a labor and employment background, we want to touch briefly on those, although we could really do a full CLE on either of those acts. The Pregnancy Discrimination Act was enacted in 1978, and that was in response to really a Supreme Court decision. And that decision was General Electric versus Gilbert a couple years prior. And that decision said that pregnancy was not covered as part of sex under Title VII. So Title VII of the Civil Rights Act protects against discrimination on the basis of, among other things, a person's sex. The Supreme Court said pregnancy is not part of sex under that act. And Congress said, no, we think it is, and so enacted the PDA. It applied similarly to employers of a size that Title VII applies to, so 15 or more employees. It did prohibit discrimination on the basis of pregnancy, childbirth, or related medical condition, which is familiar language that you'll hear a lot about today under the PWFA. But the gap that that law left was really it required comparator evidence. And so it treated pregnancy as a temporary disability. And so for an employee to show a claim, they really had to point to a comparator employee, so someone who had a similar position, reported to the same supervisor, to say that you are treating comparators who are disabled differently than me, who is pregnant. And so a lot of times that comparator evidence just wouldn't exist. And a lot of times you would see a successful claim under the statute come up with light duty programs. So maybe people who are disabled, employees who are disabled would be able to participate in light duty, but a pregnant worker would be denied the ability to participate in light duty. The second law that led up to the PWFA is the Americans with Disabilities Act. And that was enacted in 1990, and it was amended by Congress recently, fairly, in 2008 under the ADAA, which is the Americans with Disabilities Act Amendments Act. Quite a mouthful there. Similarly, this has coverage for employers with 15 or more employees and has really two key components. There's an anti-discrimination component to that law, but the one that really relates more to today's topic is the reasonable accommodations part of that law, which really said, you know, for qualified individuals with a disability, you have to provide reasonable workplace accommodations. And those could be either things like modifying the facilities in the workplace or things like modifying how the actual job was done. So making a change to how the job's essential functions were performed to allow that employee to keep working and performing their job with some type of accommodation. There are a couple exceptions under that law. One you'll hear some more about today, which is undue hardship, and I won't kind of spoil that for later in the presentation, but there are a lot of factors you look at for whether a particular accommodation would cause that specific employer an undue hardship. And then direct threat, which comes up less, but we see it coming up sometimes now with some mental health disabilities, particularly is whether that employee would cause a direct threat in the workplace to themselves or to others. And so these two laws kind of left a gap because a lot of times workers who are pregnant might have a condition that would rise to a disability, which would be covered under the ADA, but sometimes they would need an accommodation that did not rise to a disability, or they could not point to that comparator evidence. So a lot of kind of the I like to call them the everyday aches and pains of pregnancy, which I've just been through. They totally feel like disabilities, but they do not all rise to disabilities. So the PWFA is going to fill in a lot of those gaps for pregnant workers and allow them to hopefully stay in the workforce. So with that, I will turn it to the PWFA overview and send this to Ashley.
Jackie.
You're welcome.
That was a great introduction. And now we're here, right? We have the Pregnant Workers Fairness Act. So we're going to talk about what it is and how we got here. And as Jackie mentioned, one of the key purposes of this act is to keep pregnant workers in the workforce for as long as possible and as long as they are able. Along with that, some of the other purposes are to maintain the health of the employee, maintain the health of the pregnancy while they're still working, but also to lower the requirements for accommodations for our pregnant employees, right? And I say employees because I'm a corporate lawyer, so please don't take that literally. For our employees who are pregnant, that's what this is for. About the PWFA, the act was enacted and became law June 27th of 2023. However, the EEOC just issued its final regulations in June of this year. June 18th, the final regulations took effect. Who does this act apply to? Every employer who has 15 employees or more, who is engaged in an industry affecting commerce, whether it is federal or state, public or private, and this does apply to unions as well. So when asked who does it apply to, if you have 15 employees, you just raise your hand because it applies to you. And so this is basically, as Jackie mentioned, a gap filler that applies to almost every employer. We want to get into some of the specific language that you'll find within the EEOC's final regulations that were just put in effect in June of this year. So the regulations state that it requires a covered entity to make reasonable accommodation to the known limitations of a qualified employee related to pregnancy, childbirth, or related medical conditions, absent undue hardship. Now, there are a lot of elements just in that language alone that we'll get into more detail about later on in the presentation. But we just wanted to give you the raw language as it exists in the regulations. This is what you'll see if you go and look at those. Further, it goes on to say that the PWFA prohibits a covered entity from requiring a qualified employee to accept an accommodation other than a reasonable accommodation arrived at through the interactive process. And that'll be really important to remember once we start talking about leave as an accommodation and whether or not that is reasonable to offer to our pregnant employees. More language, the PWFA prohibits the denial of employment opportunities based on the need of the covered entity to make reasonable accommodation to the known limitations related to pregnancy, childbirth, or related medical conditions of a qualified employee. Something important to note here is that the PWFA works in tandem with Title VII, right? Title VII also provides some protections around termination of pregnant employees or failure to hire. So they work together and afford protections under both. Moving on, the PWFA prohibits a covered entity from requiring a qualified employee to take leave if another reasonable accommodation can be provided to the known limitations relating to pregnancy, childbirth, or related medical condition of the employee. That last part of this, you're going to hear a lot as far as related to pregnancy, childbirth, or related medical condition, because it's very important to the PWFA. And luckily, Ian is going to explain all of that for you in just a few seconds.
We're going to have the man tell us all about the related medical conditions.
So there are some other provisions of the PWFA that we wanted to point out for you. One of them being the anti-retaliation provision. So the PWFA is very specific that you may not retaliate against any employee for requesting an accommodation pursuant to the PWFA. Now, what's interesting is this prohibition against retaliation applies to any employee who may witness, experience, report, or have anything to do with bringing a charge under the PWFA with the EEOC. So when we say that it does not have to be the qualified employee, really any employee is protected under the prohibition against retaliation. There's also an anti-coercion provision, which speaks to intimidation, threats, and harassment. All of that is prohibited as well. Important to know that failing to provide an interim accommodation for an employee who may request an accommodation under the PWFA can be considered a violation of the prohibition against retaliation. So when those requests come in, it is really in the best interest of your clients or the company to provide some type of interim accommodation while you work through the interactive process. The remedies under the PWFA actually mirror those under Title VII, right? So you have the same remedies as far as punitive damages, front pay, back pay. Very important to consider emotional stress and emotional distress as damages in these type of charges. Other than that, there is a prohibition or a provision that speaks to unnecessary delay in making accommodations. As I said previously, it is always in the best interest of the company or your client to work with the employee to try to put some interim accommodation in place, because an unnecessary delay can be a violation. And when we're looking at unnecessary delay, we look at several factors like time, the complexity or simplicity of the accommodation being requested. So those are really important provisions to be aware of. And we're going to break that all down in detail here in just a second. So I'm going to pass it over to Ian, and he's going to get down to the nitty gritty.
Thanks.
You're welcome.
And thank you for inviting me to the panel. First of all, I want to address something that you might be thinking. You see all these outstanding panelists next to me and these fantastic lawyers. And you might be thinking to yourself, is he the token plaintiff's lawyer? So yes, you'd be correct on that. So I'm happy to talk about the breakdown on this. And as Samantha-Anne mentioned, yes, I will be breaking down what the protections are.
Token few things on this panel.
Indeed. So happy to break this down. As a plaintiff's lawyer, we want to break down the different aspects of this law, because I've actually been filing, even though this went into effect in June, I filed a number of charges of discrimination with the EEOC under the PWFA already. And as a practice pointer, if you're looking at it from the perspective of the employee, you want to make sure to identify, don't assume necessarily that the EEOC is going to know that that the PWFA is going to apply to your particular complaint. So I've been adding that to my charges. So the specifics here are known limitations, as you can see. Here, it doesn't have to be the communication of these known limitations. I would point out it could be to the supervisor, to the manager, to the supervisory authority, to whoever regularly directs the employee's tasks, to human resources personnel, another appropriate official, and also pursuant to whatever accommodation policy that the company's established. And a lot of times companies are going to have accommodations policies that are going to be tailored to the ADA. So as a practice pointer for companies, that's probably something to look at as well for how you want to address this, because any kind of communication by the employee of these known limitations pursuant to the EEOC's final regulation rule says that it can be in writing or verbal. And they don't have to use medical terminology, and they don't have to cite to the PWFA specifically. So that's important to keep in mind. So you need to be able to spot
for you
this.
on this one, because I think it's interesting it's communicating what the known limitations are. Is communicating that you are pregnant enough?
I don't think communicating, and of course we don't have any case law to be able to guide us, but I don't know necessarily that saying that pregnancy is enough. because the basis of the PWFA is dealing with accommodations. And one I don't think personally is going to automatically assume you're going to need accommodation just because you're pregnant. Now, being a guy, I'm not going to say necessarily that I know what it goes through, with a
I
pregnancy.
also have no idea, which is why I was asking.
But I would point out that the no limitation relates so broadly that it would be better safe than sorry to make sure that a company asks to understand what the nature of the needs are of that employee to do the right thing, but also to cover things from a legal perspective as well. And I think that's always a good perspective to be able to take, because you want to make sure that you understand whether or not there are any needs on the part of the employee. But specifically when you're talking about this, you need to engage directly with the employee whenever possible. And as I mentioned before, we don't have a lot of case law. The case law you're going to wind up hearing from are the initial types of cases that have come out, where you have states that are seeking injunctive relief that Samantha-Anne is going to talk about after mine. So you want to make sure when you're looking at the writing, you're looking at text, you're looking at emails or anything else for the particular accommodation. But to be clear, it is requesting the accommodation. That's the thrust of that, and we'll be getting to accommodations in a moment. Now, when you talk to when you look at the employee, is the employee a qualified employee? And you would note that if you're familiar with the Americans with Disabilities Act, a qualified employee would be someone who's substantially impaired in one or more major life activities. What the EEOC in the final rule did and the law did is it expands that for qualified employees. It does take and draw from the ADA in terms of whether or not you can perform your essential functions with or without reasonable accommodation. But it does broaden out what the reasonable accommodations are and does allow for suspensions of the performance of essential functions. For example, you could wind up having a situation where you, the employee, can't perform one or more essential functions, but only for a temporary period, or you perhaps can perform them in the near future. Now, the EEOC has addressed this in the final rule when you talk about temporary period and near future. Temporary period is not defined, but it is a limited time period. It's not permanent. And when you look at near future, what the EEOC in the final rule said, that they liken it, the EEOC likens it to being in the near future of within 40 weeks, because the EEOC stated in its rule that 40 weeks is considered to be the end of the term of pregnancy. Now, obviously, pregnancy there's different time periods for that pregnancy occurs, but the EEOC did put down 40 weeks as being in the near future, but that's tied to pregnancy. Now, if it's not related to pregnancy, then near future is not defined by the EEOC, and the EEOC did not specify a specific or set a specific limitation on the amount of time as to what near future is. So I imagine that we'll be seeing that in cases coming down the road at some point in time once these matters start getting litigated. The employer also can't consider mitigating measures. And what's important is if the employee rejects the reasonable accommodation or whatever the reasonable interim accommodation is, then they will not qualify for that reasonable accommodation. On the flip side, the employer can't force on them a reasonable accommodation if a more effective reasonable accommodation is available to the employee. So these are all trade-offs and balancing acts that you're going to have to take a look at from both perspectives and both sides. Now, when we talk about what is it related to, it's pregnancy, childbirth, or related medical conditions. So when you're talking about pregnancy, as Samantha-Anne just mentioned, if someone's pregnant, it's not just that, it's also related to childbirth and any related medical conditions that arise out of pregnancy, childbirth. So what you look at is, you look at the during, and you can look at the afters and the before as well. So first of all, you're only looking to the specific employee in question. If you're familiar with the Americans with Disabilities Act, there is an association clause. Now, under the Americans with Disabilities Act, you can't get a reasonable accommodation if you're bringing the claim under the association clause. This relates similarly to the PWFA. You can't have an association to the person who's pregnant and seek the reasonable accommodation. You have to be the person who needs the reasonable accommodation. You have to be the person who has the pregnancy, childbirth, or related medical condition. Now, this can be modest, minor, or episodic. Again, that is an expansion of the ADA to where the ADA doesn't cover these kind of situations where they're minor or episodic. It could be for maintaining the employee's health or maintaining the pregnancy health. It also includes seeking health care. And one thing is it's so broad that it need not be the sole, original, or substantial cause of the medical or the physical or mental condition that's in question. So if we talk about what are those conditions for pregnancy, childbirth, or related medical conditions, it runs the gamut, and there are a lot of them here. You could talk about infertility, fertility treatment, use of contraception, termination of pregnancy, and it runs the gamut of termination of pregnancy, whether it's miscarriage, stillbirth, abortion, ectopic pregnancy, preterm labor, pelvic prolapse, nerve injuries, cesarean wound infection, cardiometabolic disease, gestational diabetes, preeclampsia, anemia, cardiometabolic disease, endometriosis, sciatica, carpal tunnel syndrome, migraines, dehydration, hemorrhoids. All of these and more can wind up being related medical conditions. So we go through also the rest of these as well, and it talks about also different symptoms that can arise from it, whether it's nausea, vomiting, edema, high blood pressure, infections, antenatal or postnatal anxiety, depression, psychosis, frequent urination, incontinence, loss of balance, vision changes, varicose veins, hormone changes, vaginal bleeding, menstruation, and lactation-related conditions. So you could see this is very broad in the nature of these conditions. This is a game changer, in my view, and really helps employees along these lines, because if you talk about all the different conditions that you're seeing here that weren't necessarily covered and had to be argued under the Americans with Disabilities Act are now covered under the PWFA. And as Ashley mentioned before, one of the accommodations, when we get to that in a moment, is going to be reasonable leave. But one thing, if I could take an aside, when you look at lactation, there are other types of laws that cover lactation, which we're not necessarily going to get into now. Lactation has been extended as being covered under Title VII. Also, there are two federal laws you're dealing with. Under the Fair Labor Standards Act, you're able to get breaks for pumping, and also there's a new act that came out right around the same time as the PWFA called the Pump Act. Now, Congress loves to use really cool acronyms. So PUMP stands for, and I have to always keep remembering this, providing urgent maternal protections to nursing mothers. But I don't think PUMP NM really sounded very good with Congress, so they just kind of left it with PUMP. Yeah. But the PUMP Act is also something to take a look at, because that provides certain protections as well.
Now, Ian, I've got a question that has come up in our company, and for Ian and all of our panelists here. When we talk about qualified employees and some of the medical conditions that they experience, is it arguable that the PWFA may apply to men?
That I haven't seen be addressed. I think that's what happens is where it's come up is in parenting issues that I've seen interpretations that where men are the association clause that I addressed, but unless a gentleman has a pregnancy, childbirth, or related condition to childbirth and pregnancy, mm-hmm. I don't see how that could extend to that. But the association discussion that the EEOC has, I think, addresses that point.
I think in everything.
Because it's not about parenting.
Yeah, it was very specific that it wasn't about parenting, and it has to be accommodations and a medical condition to the person who carried the child.
Mm-hmm.
Yeah. We had that actually come up in a gentleman who was going through fertility treatments, and I think opinions have been split, but it has not been addressed. And I think the majority of us know that it does not apply to men. So I always like to share that or ask that question because it has been brought up.
I think the difference is where I saw and what we kind of talked about internally is we struggle with the word related in the definition because I think like every dad I know is relatedly tired.
Yeah.
But or they have related anxiety. But I think the key is that this is a caused by.
Yeah.
And so we, instead of caused by, is this condition caused as a direct result of the pregnancy?
Yes.
Versus is it of the pregnancy process or is it related to? Because related to is a lot of things. Caused by is different.
Yeah, and I think we're not, and unless we're dealing with a reality of I don't know if anyone's familiar with the old movie Rabbit Test, where Billy Crystal is pregnant. So it was Billy Crystal pregnant anyway, where the guy was pregnant. That reality, when you're talking about it, the regulations specifically say it's relating to that specific person. So that specific person has to have pregnancy, childbirth, and related medical conditions. And the EEOC was very specific in terms of this doesn't apply to parenting. Now, if he has some type of, like you said, the related anxiety, no, I don't think that would necessarily, because I think it has to derive directly out of the pregnancy and childbirth.
Yeah. And I think that's where I've seen it come up. Like dads can be depressed after birth too, or spouses. They can get similar to postpartum depression, but I think it's more for the birthing employee. But I think the related to, it's important to remember, I think that's just meant to say after the fact, or tangential to. So you have to look at the before, because it does deal with infertility treatments and actually, conceiving a child to some extent. It applies to the during the pregnancy, and then it applies to after, which is really important. There's a terrifying statistic I read while pregnant, which I wish I'd never read it at that time, but actually for maternal mortality, of women who die related to childbirth, a third of them die within the year after pregnancy. So there are a lot of conditions that pop up after the fact, even up to a year after that pregnancy. So I think that's what that related to is meant to encompass. It's really the after the fact, all those conditions.
Yeah, and that's really important because the only extension that I've seen, and perhaps if y'all correct me, the only extension beyond childbirth that I've seen in Title VII is lactation. So this is, as you heard before, you could be talking about multiple different types of symptoms that come postpartum depression, postpartum symptoms. But again, it's for the individual that it's addressing who is pregnant. One side note: this does talk about accommodations such as leave for abortions. However, Samantha-Anne's going to address some injunctions that have been recently granted relating to that as well. Yes, Emma.
Hi, we have a question in the chat that says, is an abortion or qualify as a related medical condition?
Well, having the abortion itself, I would assume, because it's a related medical condition, because abortion is addressed specifically in the PWFA. And
it falls under the exception of health of the mother.
It falls under the exception of the health of the mother. Then that's a related medical condition. But you have several lawsuits where injunctions have been granted relating to that provision that Samantha-Anne will address. So the next, sorry.
It's okay if we ask a question in the middle, or are we going to wait to the end of the question?
No, go ahead.
Go ahead.
Regarding like IVF treatments, those are before the pregnancy. Does that mean that they don't have any? There's no.
No, IVF is accommodated.
Yes.
Under this act?
Yes, under this act.
Oh, okay. But even though all of that was prior to the pregnancy occurring?
Pregnancy process.
It's all part of the process, yeah.
Okay.
Medical pregnancy process, to be clear.
Okay.
Yeah, that's why when we're looking at it, when it says related to, we're talking about pre, during, and post.
Okay.
And that is right here when you're talking about related to, affected by, arising out of. So, for example, pain when it's standing. So these are the different types of symptoms that can be addressed when this is going on. Pain when standing, you can't lift more than 20 pounds. Time off for prenatal appointments. Therapy for postpartum depression. Limiting exposure to secondhand smoke. Breaks to eat for lactation. Time off for amniocentesis. Time off for IVF treatment. So you must have had ESP because you segued that perfectly. Fatigue from pregnancy and back pain from pregnancy. You have all these related conditions that are related to, affected by, and arising out of. And related to, as has been discussed, is a very broad topic. And I'm sure that some of y'all who are litigators, you would probably object whenever someone says related to when they have something in a discovery response as being overbroad, vague. related to, this is going to be one of those things that's going to probably have to wait till it comes down through the courts to see how that's addressed. Now, reasonable accommodations that can be asked for. I would point out, when I was looking up some anecdotal information on this, CNN, in an article, according to CNN, they cited the National Partnership for Women and Families, stated that 70% of all pregnant women worked while they were expecting. 70%. So you wonder why it took until June of 2024 to get this act passed. But nonetheless, thankfully, the act has been passed. So we're looking at the reasonable accommodations. And we were talking about schedules, and we were talking about leave. Schedules are some of the biggest things that we see as plaintiff lawyers and probably employers see when it talks about trying to adjust some accommodations for individuals. So you're seeing this kind of scheduling, you're seeing the adjustment of the schedule, the change of the schedule, perhaps changing to another shift or what have you. That flexibility has been very, very important, and now that's built into what can be a reasonable accommodation under the PWFA. So that enables the employee to perform the essential functions, enjoy equal benefits and privileges of employment as a similarly situated employee does, and also allows for temporary suspension of essential function, unless there is an undue hardship. And Samantha-Anne is going to be discussing that as well.
I'll jump in real quick.
Yes.
At the beginning, I talked about the Americans with Disabilities Act. Under that law, which has existed for a while and protected certain conditions under pregnancy, you do not have to suspend an essential function of a position. And so the employee under the ADA has to be able to perform their position with or without reasonable accommodation. And so if they couldn't perform an essential function of their job, you'd say, okay, employer, you can terminate the employee, you can put them on leave, all of those things. That's a major point of the PWFA. Now you actually have to suspend that essential function. And if it's during pregnancy, that's up to 40 weeks that you have to suspend it. And I think that's what some companies are grappling with, where it's atypical to how they've always administered their leave process. So it's a new way of thinking about it for pregnant workers or qualified employees under this act.
It's also hard on companies, which is what I'm going to talk about in a few minutes, to suspend an essential function.
Yeah, and that's therein lies the undue hardship. And I've had cases where we do, as Jackie was saying, where we're trying to seek leave as part of the accommodation. And sometimes, and there's case law in it, sometimes that leave is not necessarily viewed to be an accommodation, even if it's for someone who's pregnant. And then you're still looking at the intersection between the Pregnancy Discrimination Act, the ADA, and also now thankfully you have the PWFA, which codifies it so that we can be able to ask for that. So then finally, we're looking at reasonable accommodation examples. There are several that the EEOC, I believe, uses per se examples of reasonable accommodation. That's carrying and keeping water to work, breaks for restroom, eating and drinking, sitting and standing. Those, I believe, are viewed as kind of per se accommodations under the PWFA through the EEOC final regulations. But here you have all the rest of these examples, for time, for the purposes and sake of time. Yeah, we don't have to go through them all, but if you take a look, I'll give you a moment to take a look through that. A lot of these have not been accommodations under the ADA, such as the paid or unpaid leave, such as the change in work site, potentially, such as telework and remote work. But I would point out, under telework and remote work, and we'll see an example for this, you had, before COVID, you had a lot of companies saying, no, that's not a reasonable accommodation. With COVID and with so many people working telework in hybrid positions, that everyone has seen that you can do that and that's acceptable. And as a result, that's now tougher for employers to argue that that's not a reasonable accommodation. So with that, I will also waive any defense. If any of y'all have a case against me later, anything that I've said, in any cases, if the court interprets something completely different, I'll go with what the court says down the road on a case. So I'll hand it over to Samantha-Anne.
For sure. I'm going to talk implementation. I'm a corporate lawyer. I've been a GC or an AGC for about 10 years. I'm also not a mother because panels like these have terrified me out of that completely. So thank y'all for that, because it does sound like a hardship. It sounds very, very difficult. And so, but being on the other side is getting to implement this, and not having gone through it myself, I actually think I get to see more war stories being on the in-house side. So that is why, as a non-labor and employment specialist, I'm going to talk about implementation, because we see it all. So undue hardship is something that's very real for a company. This is supposed to be, the accommodations have to be something. Ultimately, at the end of the day, and this may sound very harsh, but companies have to work. Our job is to get that commerce function done. We can't allow a lot of things to get completely in the way of that. It can't be that this shuts down because people get pregnant, this shuts down because people get hurt. Those businesses have to keep going. So what is an undue hardship for a company? So significant difficulty or expense, those are things where you have to look at your weighing of, is this accommodation that I'm making, is this an undue hardship? Is this going to cost us a ton of money? Is this going to be something that would be considered extreme? What is the nature of the accommodation? Is allowing an employee to bring water into an area, is that something that is, would y'all say that that is an undue hardship?
Probably not.
Probably not. Let me give you an example. My company owns a chemicals plant. We have a chemicals area where there are people that are chemical blenders, where water is considered a volatile addition to the chemicals that are being blended. Is that now an undue hardship if the chemical plant could blow up if you bring water into that protected area? Yes, that is an undue hardship. You could kill the entire rest of the workforce. So some of these are going to be, what is the difference? Is this going to be, you can bring water to your desk at Baker Botts, or is it, you can't bring water into a protected area at a nuclear facility? So these are going to be different based on every company, and each company has to be the one that evaluates, is this an undue hardship for us? What's the net cost? Is it going to be something that ultimately plays out? I think that a great example of net costs are lactation rooms, because it's something that's not used just specifically for one. It's a cost up front, but it's used long term. It's going to be used long term by a lot of people. So that net cost, if you break it down per person, really becomes a lot lower, and it's not an undue hardship on a company. Overall financial resources of the facility and the company, a company with 15 employees, 16 employees that falls under this, that net is going to be very different than, say, a Jackson Walker with thousands of employees. So you have to really look at, is this something where adding a lactation room in a company of 16 people where there is one female that works there and they have a very limited amount of space in a high rent area versus putting it in a large office? So you are always going to be looking at that undue hardship based on your specific company, and it's going to be different, as well as your type of operations. So being pregnant may not affect you being a seated attorney as much as it might be a rig up tech on an oil well. Those are very different types of careers that are affected very differently. Pregnancy is hard for both, but if you are having to stand and deal with chemicals and wear PPE out on a site, that's going to be a little bit different than how can we accommodate you in an office. And so you're always looking at your operations and your type of job function and your impact on operations. So if it is something where you are going to have a massive impact on operations because there are accommodations made or because you can't do your job, that's very different than can we move you to a different position. So always looking at what is that essential function? How can we accommodate you? Is it going to have an overall impact on operations? If you're the only one that can do that job and you're pregnant, reasonable leave may not be something that could be considered because it is a true undue hardship. So you have to really look at what the situation is, what the size of the company is, and what the nature of their operations are. And so if you're looking at something like, I'm in oil and gas, so I feel like that's always in manufacturing, that's always my default. But if you're looking at someone who can't be around a chemical fumes and their only job is being a chemical blender, that's something, is a reasonable accommodation a gas mask or a breathing system? Or is it leave for 40 weeks for an employee that can't be around it? Those are two very different types of accommodations. Arguably, one would be an undue hardship, losing an employee. The other would not be an undue hardship. It would be something that they could make. So you have to evaluate that individually based on what the company is. That goes into the essential function suspension point of how long is the employee unable to perform? It's very different of, is it you can't 20 pounds for 40 weeks, that's very different. Or is it something where, what if it's a 2-year long situation and that position has to stay? Going into FLSA protections too, of how long can that person be out? How long are you protecting that job? And how long are you missing that essential function? What is the nature? Is it key to your business, or is it something that you're able to suspend and you're able to break up between other employees? Frequency, how often do they do it? If this is something that is a once every 8 weeks function, and a pregnant worker can no longer perform that, that's not a very large frequency that is affected. Can another employee be able or unable to perform this? Is this something you can move around? I call this the labor swap because I don't always think it's fair to look at the other employee and go, so-and-so is pregnant, they can't do this part of their job now, so you get this too. So we're always constantly evaluating if there's something that someone who is pregnant or is disabled, if they can't do this for a certain period of time, but they can do this, let's look at what we can move around rather than just pile on. Because I think that something that is key is realizing when you remove duties off of someone who cannot perform, it takes them away and it protects them, but we have to look on the flip side of those other employees of what have you now added. That's not a protected class, but it's a practical class. Because I'm sure someone has been in here where someone in your department has gone, and we're all lawyers, of who's been the gifted person of 10 cases while someone's on maternity leave. They 100%, we want them to go on maternity leave. We want you to bond with the children. It's the right thing to do, but it doesn't mean that it isn't hard for that attorney who just took on 10 more cases on top of their workload because we're now missing an employee. So when you're evaluating those things of undue hardship of, can you bring on other resources? Can we spread work around? Are those things we can do? We're adding this. This tends to be an accommodation that comes prior to that maternity leave. And so it does have an extended amount of time on top. Can the function remain postponed or can it be not performed for a time? There's a lot of things we do that we can push off for a bit, and it can say, hey, when you get back in 6, 12, 8 maternity week leaves, I don't know how long the standard is right now. I think it's 12 for the most, 12 to 20 for maternity leave. My company before this in France, the standard was a year, so very different. Really makes you want to think about that, Courage.
You can also retire at 60, but now 62.
Yes, and you can take, it was a year to 18 months at my last company, so it's truly enough to consider 3 or 4 in a row. But looking at how long that function can stay terminated, is it something that we could push back to Q3, or is it something that has to be done right now that's essential? So you always want to take a look at what are these essential functions and how can we do that? Is there a way we can accommodate and do this? 90% of the time I'm going to say that there are a whole lot of essential functions that can either be moved around, postponed, or just switched in order to be able to accommodate the PWFA. Because these employees but this is something that becomes a lot smaller in a 15 to 20 person company, whether it's an essential function. And so you're always looking at how does that undue hardship affect that essential function? Is it something we can move around, and what does the company do? These are things that are not undue hardship for pregnancy. Notice this says allowing food or water nearby. Yes, you may not be able to take it into the chemical plant, but there's no chemical plant that doesn't have a safe area space. And so if you are accommodating, you can put this nearby. It may not have to be on their person at all times. That's not an undue hardship on anyone. That is a basic right of life that you feed and water your people. Just very, very common. Additional restroom breaks is needed. That is something that should not cause an undue hardship. There are times where there are notice put in of planning for it a little bit more. If you are on, say, a line worker in a factory and you can't just walk away from your function, but planning that rather than being impromptu, those are not things that are undue. Sitting and standing, breaks for eating and drinking. These are all things that we would consider, I don't know about y'all, I consider these pretty basic, just being a good person moments. And so, but these are not going to be considered an undue hardship. So you cannot deny any of your employees this under the note of undue hardship. Documentation. This is key, and I think we all go back to the sick days in high school where they're like, where's your doctor's note? You can't do this, or you can't carry your books around, where's your doctor's note? So the documentation under the PWFA, they did a great job by not requiring this, because there are a lot of doctors that are not going to say, I'm going to write you a specific note of exactly what you can and can't do, especially because pregnancy has to do a lot with how you're feeling that day, what you're going through, and how your body is reacting to significant changes. And so I love that there's no requirement for documentation, because I think it has to do a lot with how the employee is feeling and experiencing. So this can change. Reasonability can change. You can have really, really poor first trimesters where there is a need for an excessive amount of restroom breaks in order to take care of your health. But that very much could change on a whim. It is my understanding that you wake up on that second trimester sometimes and everybody feels so much better. And so I think that it's very important to know that the no documentation allows for the employee's health to come first and for them to be the monitor of their health, not a doctor writing a note.
On that, where we might have new accommodations arise, whatever reason, how fast is these accommodations need to come in? An employee comes in and says, I need this accommodation, right? Depending on the size or depending on the nature of the job, that accommodation might not say, okay, we have a lactation ready for you. maybe the first point ever back no, like usually there's time delay there. Pregnancy also itself is whatever you're looking at from the employer side. Is there I would be surprised if there's a hard line rule, but is there any kind
For sure. So there's not a hard line rule, as there shouldn't be, because that's how you get in trouble. There is a clause in there that says no undue delay, though. And the undue delay is what's key, because there are things where it is, and it's a reasonability clause of it is not reasonable for someone to be able to say, there should be, I gave you notice at 8 a.m. this morning, by noon there should be a lactation room specifically. There's not. But if someone comes in and says, you know, I do need some sort of privacy, there can be an accommodation that is reasonably made of we are blocking off an area for, you know, we've put a sign on a door and we have put up a shade of some sort while that accommodation is being done. On the other hand, if someone comes in and says, you know, I'm pregnant, I have super morning sickness today and I need to take bathroom breaks, it is completely unreasonable for you to say that's not going to work for me until Thursday. So it depends on the type of accommodation, but there should not be an undue delay, and you can make an effort in making an accommodation, even if it is not the final accommodation.
Agree.
Yeah,
And remember that your delay or the time spent, those factors can be considered in whether you are violating the prohibition against retaliation to the employee. So it's always in your best interest to try to act quickly, but as Samantha-Anne said, there's no bright line rules.
Yeah, and to add to that real quickly, when you're dealing with that, you could have two reasonable accommodations, one first, and then say a month later, a different accommodation. Yeah. So you need to be able to evaluate each reasonable accommodation accordingly relative to the needs for the employer and the undue hardship, but also what's needed for the employee. And if you deny leave or deny certain accommodation, that could be viewed as harassment or the retaliation, like Ashley was saying.
And I do think a proper way, and one way that I have handled it, especially, there are times that working in corporate legal, things are brought to you that you have just not run into before. You haven't heard, and to be very frank, you don't know what to do or how to implement that, and you need to talk to a couple people. There have been times that this is brought to me where an accommodation is requested or something, and I don't have an answer or I don't have an ability to do anything that day. What I consider my appropriate response is we absolutely need to act on that. I am not in a position where I can do this to put you in a comfortable situation today. I would encourage you to take the day off on us while we figure out what we can do, because you don't want to retaliate and put the employee in a bad situation where they're not able. But you can say, as a company, I am working on this. I don't want this to be an undue delay. So if you are comfortable with it, please take the day at home so you are in accommodations you've provided yourself, and the accommodation we're providing you is you don't have to be here.
Yeah, and I think it's all very fact specific, and the EEOC in its regulations and guidance actually does recognize that to an extent, a miracle of miracles, where there are administrative things you need to go through. So the EEOC even gave an example where, you know, an employee came to someone on a Friday and asked for an accommodation, and the person wasn't sure, you know, do we do this? What do I need to do? And so the response of, I need to take this to human resources. I will get back to you. In the meantime, let's not have you lifting these heavy boxes. Can you lift these lighter boxes that are within the accommodation you're requesting for the rest of the day? And I'll get back to you as soon as I go talk to HR. And the EEOC recognized, like, yes, some level of reasonable administrative time is still going to fit within what you need to do under the Act and isn't going to be considered this undue delay. But the undue delay is really meant for those companies that just don't want to comply. And so they think pregnancy is a temporary condition. We'll just keep pushing this out, and pretty soon the baby will be here and we won't have to deal with this.
I think one good example too is has to do with lactation and pumping afterwards. If you are planning on coming back to work and say you've communicated what your first day is and you have said nothing, showing up on your first day and expecting there to be a lactation room ready for you, I don't know if that's reasonable on you. I think that part of that communication is being able to ask for that accommodation. If you're going to expect it on day one, when you're communicating about your return to work, saying this is an accommodation or this is something I'm going to need is very appropriate. And being able to say that, you know, if you show up on the day and it is 10 minutes before you need privacy in a room, and I work in a fishbowl. There is like no privacy. There are no set rooms other than the restrooms. So if you show up on the day and in 10 minutes you need to say, you know, I need a closed room where I have full privacy, if it's not something that they can provide, and that communicating early to your employer is key, because it does give them some of that reasonable time to be able to handle your accommodations.
It's absolutely true. We actually just went through that situation. We had an employee come back and communicate with us that she works at a service center. Service centers house our linemen, gas techs,
But they're a cube
primarily
farm.
male.
They're cube farms.
They're cube farms, not a lot of space for lactation and to be comfortable and do that. So we actually made preparations, and that led to lactation rooms being in all of our service centers, because we do have admins and secretaries and things that need that. But had she not spoken up and communicated with us weeks ahead, then probably would still be without that. Where it's different in our corporate tower downtown, where we have those built out, we probably didn't think about people at the shops and in the welding shops down in South Houston and our service centers. So the communication is really key.
Yeah. So some of the documentation, there are, even though it's not required, there are requirements of what is permissible for part of your corporate policies. As part of corporate policies is documenting what you're doing and why. So you can confirm the condition, the workplace change required. Confirming the condition doesn't mean that you have to have a doctor's note saying you're pregnant. It can be an email from me saying, I am pregnant. That is confirmation enough. From a healthcare provider, you can ask. You can't give them the exact form you want it filled out on. Self-confirmation by a simple statement, as I said, an email made in a specific manner, which means I am pregnant. It does not mean I am 12 and a half weeks pregnant with a boy. You cannot ask those specifics in order to be documented. And enough information to establish the qualification of, there are different functions of pregnancy of where you're asking. So you do need a little bit of information in order to confirm. For example, someone saying I am pregnant, I need a private lactation room. Very early in, that is typically something that is a little bit later on in order. So you do need a little bit of detail to confirm the accommodation.
Question about service nurse. I specifically represent law enforcement. I understand there's obviously
Yes.
aspects to that job. And I've gotten lots of questions. But they'll notify their agency that they're pregnant. And an example of, well, then they require them to fill out a fit for duty form. And according to this, that seems like that is taking it too far, necessary. We're already transferring them out of the spot to take them out of. But to say, you can't require a fit for duty, it's not required.
So I think, and this is, I think it has we probably have similar thoughts, because I'm real fit for duty to sit at my desk and draft legal pleadings, but I'm real not fit for duty to go be a rig up tech if I'm, 12 weeks postpartum or am not allowed to lift 20 pounds. I think a fit for duty form in some of these permissible and reasonable documentation requirements are going to be job specific. If there are physical requirements in testing, being a police officer has a physical exam at the beginning. Being a corporate lawyer, fortunately, does not. Thankful for me. But if those are part of the reasonable standards that everyone is subjected to, it no longer becomes a situation where if I was a police officer that had a concussion and was looking to return to duty, I would also be required to fill out a fit for duty form. So that is not a policy that is going to be specific to pregnant workers. And I will let the real lawyers in the room confirm that. But it is something that is part of your general policy that applies to everyone. So it would not be considered discriminatory to have a fit for duty form for any medical condition.
Well, I think in most of not apply to that situation.
Based on my reading of the final rule, I think I respectfully disagree with my panelists a bit on that. I don't know that necessarily a fitness for duty is allowed under the PWFA if it's directly related to pregnancy, based on what I read in the final rule. Now, of course, with Chevron deference going out the window, no one really knows what's going to happen with the courts. But to answer that, I don't think it's that clear.
Yeah, I agree. I think that, and this is something we have to be really cognizant of, because a lot of large companies will use a third-party administrator, and the PWFA just doesn't allow for a one-size-fits-all form for accommodation.
Yeah.
So I would advise against that.
I think it's going to be hard. I think there's going to be a lot of learning curve. I say this as someone, and it's not certainly something you're going to like find on my LinkedIn, but I receive an accommodation from work under the ADA. I am considered legally blind by all agencies because I have a brain tumor. And so I have been what's considered a disabled attorney for 15 years now. And I have never had to have a fit for duty form, but there are times where there are other job activities where you do have to prove you are fit. I think we're going to see a lot of case law, a lot of challenges, probably at least 3 by Ian. I hope you make like a big one though, like a famous lawmaking one that I can cite and say that I knew him. But I think you're going to see a lot of evaluation on that. I think the key right now is to understand that this is going to be something that is explored. It's going to be something that's challenged. It's already been challenged. And so understanding that doing your very, very best to either advocate for yourself as a pregnant worker or to accommodate as a business, making sure that you are able to show those good faith efforts is going to be something that is key as you move together and that you work together accommodatingly in open communication. That's where on the corporate side, I say, we are only able to accommodate what we know. And that is my favorite thing to say of please bring to me what you need. We're only able to accommodate what we know. But the amount of times that I've heard someone say, I told them that I couldn't lift this, or, I was late for work 10 times because I had morning sickness. They can't discriminate against me because I'm pregnant. And the exact response from every single person in the company was, wait, you're pregnant? It's very hard to make an accommodation for something you don't know, because if someone is late because of a condition, that is different. And we are able to make that accommodation if it doesn't affect work. But if the rule is you start working at 9 o'clock and you are the only person that's being late and we have no idea, it's very different. So part of it too is sitting down with your employee and saying, hey, you've been late a couple times. Do we need to talk about anything? How can we help you? But making sure that you're communicating with your employer too, so that they can make those accommodations.
And I think too, also having that safe space too, if it's human resources or someone else they can go to, because they may not feel comfortable, especially telling their supervisor, especially that first trimester. Anecdotally, that's where a lot of issues are going to come up with morning sickness. You're starting to really feel things. And then that last trimester. So that first trimester, they may not feel comfortable talking to certain people, and they may just think, I will just get through it. And then when I start to show, I will ask for things. So like letting them know, you need to actually communicate this and tell HR or whoever it is that can keep it confidential if they're not ready to shout from the rooftops yet, I'm pregnant, because a lot of things can happen in pregnancy. And they may just not feel comfortable yet. So I think that's really important too, is communicating like where you can go to.
And it's the same with ADA. If you walked into my company right now and said, who knows Samantha-Anne is blind, like 4 people would raise their hand. They would also know, though, that I have one of the coolest monitors that's way bigger than a lot of people's. And that might be where they figured it out. But not everyone needed to know that the accommodation they made is that IT bought me a new monitor so I could see better. And then it's on the left side as opposed to the right side of my office. And so part of it is just knowing and having that safe space. Some of we've talked about the accommodations that we can make and what is reasonable and how to evaluate that. There are legal challenges right now. It's interesting. The Texas challenge over the Consolidated Appropriations Act has nothing to do with the actual text. It has to do with the procedural piece, because lawyers love that. So it had to do if it was passed properly and voted on by a quorum or not. There is a fantastic article by Jackson Walker online, which is where I got most of my information on it. So well done. And then a challenge to the abortion accommodations. A lot of that is going to be if it's related to the health, because even one of the main challenges is that even in an elective abortion, there are health challenges that are affecting of the mother. And then injunction has been granted regarding elective abortion accommodations in Louisiana and Mississippi, of all states. You don't normally hear Mississippi leading the law, but, and that's my home state, so I can say that. But there are challenges that are effective. So that is part of it, of being able and being on top of what your laws are right now, and making sure that you are staying current is key. We were going to talk about some examples. I don't know if we have any time.
Yes, so I will say we are over on time. If people want to stay and our panelists don't mind staying, we're happy to read those examples. But if anyone had like a 1 o'clock deadline and had to get back to work,
We will not be offended.
Yeah, they will know if you have to leave. Do people want to hear examples, or do most people want to stay? I see some head nods. All right, well, panelists, we good? We're going to read through some examples?
Let's do it.
All right, so telework. Rame, a social worker, is pregnant. As her third trimester starts, she is feeling increased fatigue and needs more rest. She asks her supervisor if she can telework and see clients virtually so she can lie down and take rest breaks between appointments. Although her company has the technology to conduct virtual appointments, her supervisor prefers Rame to continue to see clients in person because it provides a more personal experience that is beneficial to the clients. What should the employer do in this situation? Is this going to be a reasonable accommodation request or not?
So I think first you start with the analysis where essentially suspending an essential function of her being in the office. Is that essential or not? And
Nope.
Is there undue hardship? So that's kind of all the things you need to think through with this. I think Samantha-Anne did a great job earlier thinking through, these are all the things you need to consider. It's all very fact specific.
And if this was brought to me sitting in legal, I think we would agree on this. This would not be an undue hardship for the company.
No.
There is no technology purchase, so there is not a monetary. This is not a huge change. This is something where if there are clients that have a more personal experience, it does not sound like these are new clients, that their experience they may have a more beneficial, but they will not have a lesser experience, which is key. And this is not something that has an effect. And they could very easily change clients and cross people that are still able to visit with others who potentially are further away. So we would not say this is
Exactly
undue.
be my recommendation.
As a social worker, if she works for the government, does that affect the analysis at all?
No, I don't think so.
WFA, like we mentioned, applies to public and private employers. So, wouldn't make a difference.
The plot twist I could see on this one, if she is someone who conducts mandatory home visits for, say, Child Protective Services, but that would be something where you look of, are those in-home visits able to be conducted by someone else? And she could absorb some back office function for those people who are picking that up.
Or can you structure the schedule of the home visits where maybe she does a home visit in the morning or the afternoon, but then she has time before and after to recover from that, and then she can see a client virtually after that.
Yes.
Yeah, and I would just mention that the reasonable accommodations for telework, as I stated earlier, have become a lot more flexible and courts are much more receptive to the argument that telework or hybrid work is a reasonable accommodation. But it's very fact intensive because you can have it as a reasonable accommodation, but subject to the situation, like if they have to go home or they're required to have in-person contact and those people are only available during a set time of the day, then you might have to look at what Jackie said is changing their shift. But you'd have to look at each case, case by case scenario.
Oh, yeah, I will. That's me.
All right, so an undue hardship example. Sharon is a dental hygienist who is I'm so sorry. Sharon is a dental hygienist who is undergoing IVF. She needs to attend IVF appointments near her house every other day and is fatigued. She asks her supervisor to not see patients 3 days per week and instead of work from home assisting with billings and claims, work for which she is qualified. The employer has only one other dental hygienist and there is not enough work for Sharon to do remote work 3 days per week. Is this an undue hardship on the employer?
Arguably.
Arguably, yes. So this is what I said about the smaller companies of this is an essential function of the dental practice. They obviously are not a large dental practice where there are enough dental hygienists. And so this would be considered an undue function. Can they suspend this for 40 weeks? Arguably more, being that she is in the IVF process. So at minimum, can they suspend not being able to see their patients for, let's go with a year?
Maybe they could bring in someone temporarily, bring in a temp hygienist, but it's pretty clear from the facts they probably can't survive operationally with only one other dental hygienist, and that would be the situation that Samantha-Anne talked about with the work swap. You can't really do that. You can't pile it all on this other individual. Frankly, that individual would probably quit.
Also, I think it's very hard. There are a lot of things going on. We have to balance it with the message on the other employees too of there is a medical treatment going on, she's undergoing IVF, she's fatigued. Well, if that dental hygienist is now seeing double the patients, she is probably also fatigued. And so you do have to look at what is reasonable for the generality and what keeps your operations going. So if this was the situation in my company, we would argue this was an undue hardship and that the accommodation was unreasonable. Could we make adjustments though, rather than 3 days a week to 2 days a week, or we have 5 days a week, but 2 of those are half days, things like that. You can look at adjusting those accommodations.
I'm staying quiet as a plaintiff's attorney on this one.
Probably a good thing.
Then we get the call from Ian.
Yeah. Don't call me work, Ian.
Had my fingers crossed.
I know.
And then I think the end is just some takeaways for you because you've covered a lot of information. So just, I think one of the key things is you may have to suspend essential functions. It's very different from how the ADA would handle these types of situations. So that's one of the biggest changes with the PWFA. Train everyone. So I've been telling companies that because especially with who an employee can communicate with is much broader than what you could require under, say, an employee asking for FMLA leave or ADA leave or ADA accommodations. With those laws, you can really have a streamlined set process. With this, they can really communicate to almost anyone within the company, even someone who just directs their day-to-day work. So it may not be their direct supervisor or dotted line supervisor. It could be someone who just gives them assignments day to day, or like a line leader that they communicate a need for an accommodation. That line leader isn't going to know all of this information, or maybe even that they need to help direct that employee in that circumstance. So train everyone on how things are going to work within, your organization or within your client's organization. You're going to have inconvenience, you're going to have costs, but on the flip side, you can tell companies, you're going to have employee retention. Employees are going to probably be more productive if you're giving them some of these accommodations. And a lot of these are very small things. It's not going to be every day where you have to do an entire schedule restructure or, suspend an essential function. A lot of these things are kind of no-brainer, easy things that I think a lot of companies were doing anyway, just to be good companies, good places to work, and good human beings. But now just the law requires you to do it. But still, I would say to have companies develop forms and processes so that there is a process that workers go through and there is that interactive process. What you don't want is that interactive process to slip through the cracks and that to not happen. And then maybe think ahead about contingency planning. So think about things like, especially frankly, if you look at your workforce and you have a lot of younger females who are in childbearing years, this is going to come up. So think ahead about cross-training, about how will we, accommodate, how will we shuffle things around if XYZ happens, and thinking about that up front and in advance can really help with implementing this act.
And just to add on to the training everyone, that includes the employees that are taking it. I think what's key, and if you've ever been the confidant in the company that's had someone come and go, I'm pregnant, just don't tell anyone. I think it's key in letting know that the workers of when you are telling someone of, we need to be able to bubble this up, it's not breaking the trust, but part of this is being able to help you. And the reason that there is someone that line leader who may have no experience with the PWFA, but she does understand that she has a duty to that pregnant worker now that she is aware as the person who assigns the day-to-day tasks or as their manager, she now has the duty to make it aware, because I do anticipate that becoming an issue of reasonable accommodations are challenged, companies get in trouble because they are not making reasonable accommodations or doing something, and it comes out in discovery that someone was told and it wasn't communicated to someone who was able to make a reasonable accommodation. So training both sides is going to be key.
Yeah, and real quickly, from my perspective, you've probably seen with employment law cases or heard of them, where the underlying, for example, if you're looking at a discrimination case, the underlying discrimination case, there's a good faith case to be made, but the retaliation is the one that gets the 6-7 figure judgment because the retaliation and the causal connection, temporal proximity, and all of that looks just so compelling. The same thing here with retaliation. They have the anti-retaliation provisions, but it also comes down hard on if you denied leave, denied the reasonable accommodation, terminate someone who's made the request or put you on notice of the request, that the anti-retaliation provision can kick in. It's pretty broad. It talks about intimidation, coercion, harassment, as Ashley mentioned. So that's something that we are going to be looking at as well.
Thank you.
And I want to thank Jackie for this presentation.
Yes.
Thank you very much for the
She's our star.
presentation. And thank you, Amber, for moderating.
No, thank you, guys. I will repeat the course number one more time for those who missed it this morning.